Hi everyone, I'm Sarah Butler. I want to welcome you to today's Faith Trust Institute sponsored webinar, A Human Rights Approach to Domestic Violence. Our presenter, Allison Mckinney, is an international human rights lawyer, seminarian, and advocate for women's rights and gender equality. She's worked in the field of human rights for over a decade. Most recently, she was the Cover-Lowenstein Fellow in International Human Rights at Yale Law School, where she taught and supervised student work in clinical human rights class. Allison began her career in human rights as the Uganda Field Office Director for International Justice Mission, a faith-based human rights agency where she established and led a program to defend the property and inheritance rights of vulnerable widows and orphans. She is currently in her third year of the Masters of Divinity program at Yale Divinity School, and she completed a ministry internship with Faith Trust Institute in the summer of 2014. She earned her law degree and MBA at Georgetown University. Thank you for being with us, Allie. And take it from here.
Thank you, Sarah. And thank you to Faith Trust Institute for inviting me to do this presentation. Thanks also to everyone who's joining us for today's webinar, entitled A Human Rights Approach to Confronting Domestic Violence. As we get started, I want to begin by just giving you a sense of the purpose and the goals that I have in mind for today's presentation, and then to take you through a quick overview of what we'll be doing in our hour together. First, in terms of purpose, my purpose is to further educate and equip you to respond to the problem of domestic violence in your community. And my specific goals for today are, one, to make you aware of the relevance of international human rights law to the problem of domestic violence, and two, to acquaint you with a key international treaty on women's human rights, which is an important tool for addressing domestic violence. Here we have a brief overview of today's presentation, and I'll just mention each of these bullet points. First, I'll cover some foundational principles of international human rights. Next, I'll talk briefly about the United Nations and the Universal Declaration of Human Rights. I'll move on to discuss governments' human rights obligations. Then we'll go into domestic violence as a violation of human rights and women's human rights specifically. And then for the second half of the presentation, we'll be discussing an important international treaty on women's equality, which I'll call by its acronym Cdaw. Stay tuned for more. And then finally, we'll talk about the history and the status of this treaty in the United States. I'd like to begin with a principle that provides the foundation for international human rights norms. This principle is familiar to many of us from our experience within our own faith communities, though it is certainly not exclusive to religion. And this is the notion of human dignity, human value and worth, which is expressed in many religious texts and traditions. I'd like to offer two quotes from the Hebrew Bible relevant to the Jewish and Christian traditions to illustrate. And the first comes from the creation story in Genesis 1. So God created humankind in his image. In the image of God, he created them. Male and female, he created them. That's Genesis 1:27. And the second passage is from Psalm chapter 8, verses 3 through 6. I'll quote, "When I look at your heavens, the work of your fingers, the moon and the stars that you have established, what are human beings that you are mindful of them, mortals that you care for them? Yet you have made them a little lower than God and crowned them with glory and honor. You have given them dominion over the works of your hands. You have put all things under their feet." Both of these passages reflect the immeasurable dignity and worth attributed to humankind. The universality of this principle of human dignity is reflected in the concept of human rights, rights which apply simply by virtue of our membership in the human family. I'd like to provide you with a thumbnail sketch of some of the basics of international human rights. This is some broad, basic background to enable us to enter into a discussion about domestic violence as an international human rights violation, and to consider a human rights strategy for responding to domestic violence. International human rights emerged as a body of international law following the Second World War. The world had witnessed great human cost of war and genocide, the Holocaust. There was at that time the global political will to form a community of nations and to strive to prevent such atrocities from occurring again. The United Nations was formed in 1945, and a key purpose in forming the UN was for the member countries to commit to respect for human rights. So the charter, the founding document of the UN, states this explicitly when it talks about the purposes of the UN. It says, quote, "To achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion." So this was enshrined as a purpose of the UN at its founding, for member states to promote and encourage respect for human rights. And the member states pledged in the charter to take action to achieve these purposes. Shortly after the formation of the United Nations, the world community adopted the Universal Declaration of Human Rights in 1948. This is an essential foundation of international human rights law. It established the various rights with which the international community was and is concerned, and it has served as the basis, indeed the blueprint, for other key human rights treaties that followed. I'd like to acquaint you with some specific language from the Universal Declaration. First of all, in the preamble, it reaffirms the purpose of the UN Charter in addressing human rights and fundamental freedoms. It reaffirms the dignity and worth of the human person and the equal rights of men and women. And then to address the specific articles of the Declaration that you see here on this slide, Article 1, all human beings are born free and equal in dignity and rights. Article number 2, everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind, such as race, color, sex. Article 3, everyone has the right to life, liberty, and security of person. Article 5, no one shall be subjected to torture or cruel, inhuman, or degrading treatment or punishment. And finally, in Article 16, men and women of full age have the right to marry and found a family. They are entitled to equal rights as to marriage, during marriage, and at its dissolution. So note here the principle of non-discrimination, the principle of equality that you see running throughout this language when it talks about all human beings, everyone, without distinction. And I'd like to invite you to pause here with this language and these rights in mind and consider for a moment what it might look like to affirm and secure these rights for those who are victimized by domestic violence. How would that happen? How would these principles reflected in international human rights documents actually be put into action? Well, international human rights law places responsibility on countries' national governments to do the following with respect to human rights. And here I'm speaking broadly and generally about governments' obligations with regard to human rights. And these fall into three major categories. The first is respect. The government itself must not violate human rights of individuals within its jurisdiction. This means ensuring that agents of the government do not infringe on individuals' rights. The second duty is to protect. The government is responsible for ensuring that others, including private individuals, do not violate human rights. This means that the government is obliged to intervene where private parties are threatening to violate others' rights. It means the government must provide effective remedies to individuals whose rights have been violated. It means the government must take all reasonable measures to prevent human rights abuses from occurring in the future. And thirdly, the government has a responsibility that we call to fulfill or to promote. This is to promote the full realization of human rights. And this might include legislative and policy measures, action plans, national strategies. It could also include public information and education campaigns as further examples of ways to promote individuals' full realization or actual experience of human rights. So now that we've done our very brief thumbnail sketch about international human rights and some of the key institutions and norms, I'd like to turn to the particular issue that is our focus today, and that is domestic violence. I know that many of you are well acquainted with the facts regarding domestic violence in our society based on your work in many different contexts to address this issue. The perspective that I offer based on my work and research in the human rights field is that domestic violence is the most globally pervasive human rights abuse. Now, when we talk about domestic violence, I mean this to include the range of forms of domestic violence: physical violence, sexual violence, emotional or psychological abuse, other forms of abuse, damage to property. And remember what we've just seen in the Universal Declaration of Human Rights: the right to life, liberty, and security of person, the right to be free from cruel and degrading treatment. So that's the basis of the assertion I'm making here, that domestic violence is a violation of human rights. And I'll offer further support for that claim as we go along. But in terms of the prevalence of domestic violence, as many of you well know, this affects close to 1/3 of all women worldwide, according to the World Health Organization. In the United States, about 1 in 4 women is affected. Domestic violence is dangerous and it can be lethal. About 40% of female homicide victims in the U.S. and around the world are murdered by their partners. About 1.3 million women are victimized each year in the United States, according to the Centers for Disease Control and Prevention. And as those of you who work on this issue are also well aware, the harmful effects of domestic violence are many on both an individual and a societal level. This quote is from the World Health Organization based on a 2013 global study, and the WHO concluded violence against women is not a small problem that occurs only in some pockets of society, but rather is a global public health problem of epidemic proportions requiring urgent action. We know that domestic violence is a serious public health problem in the United States. The CDC estimates that the costs of medical care, mental health services, and lost productivity due to intimate partner violence was $5.8 billion in 1995. The impact is enormous. With regard to poverty, there's a complex cyclical interrelationship between domestic violence and poverty. Women who are less economically secure face more barriers to leaving an abusive relationship. At the same time, abuse can further erode a woman's economic position, as controlling partners tend to prevent women from pursuing educational and work opportunities. So poverty is both a risk factor and a consequence of domestic violence. And homelessness. In the United States, domestic violence is a primary cause of homelessness for women and families. A majority of homeless women are victims of domestic violence. So now we have in mind some background both on the issue of international human rights and on the nature and the impact of domestic violence. And hopefully this prepares us to move into further consideration about the specifics of approaching domestic violence as a human rights abuse. While domestic violence is a human rights issue, it has not always been recognized as such. You see, this slide is entitled, "Women's Rights Are Human Rights." This now famous phrase was invoked by Hillary Clinton in 1995 at the UN Fourth World Conference on Women in Beijing. And this is an important affirmation in that the most common violations of women's rights, such as domestic abuse, did not gain widespread recognition as human rights issues until around the 1990s. Before that time, the notion of a public-private divide meant that human rights efforts were focused on abuses most likely to affect men engaged in public political activity, abuses such as torture, political persecution, and that these efforts were unlikely to address abuses affecting women in the home, where women are often most at risk. So the efforts of feminist legal scholars and activists was critical for drawing attention to the ways in which human rights abuses against women had been ignored or neglected, and in building a movement that's arguing persuasively that domestic violence should not be exempt from international human rights protections. And the pictures you see here give you a sense of the movement and the activism that's been part of this awareness raising. It's still an ongoing effort, but more and more there are examples of domestic violence being addressed under various international human rights treaties. Now I want to turn to one of those treaties in particular, which is a very important tool for securing women's human rights, including the right to live free from domestic violence. This is the Convention on the Elimination of All Forms of Discrimination Against Women, otherwise known by its acronym as Cdaw. Cdaw is a landmark international human rights treaty designed to advance women's rights. It was adopted by the United Nations General Assembly in 1979, and it entered into force, meaning it became effective, in 1981. Cdaw is the most comprehensive and specific international treaty on gender equality. It calls for governments to eliminate discrimination against women and to remove barriers to substantive equality. Cdaw builds on that principle of non-discrimination that we saw in the UN Charter and the Universal Declaration of Human Rights. Cdaw is also known as the Women's Bill of Rights or the Treaty on Women's Equality. It's been ratified by 187 countries so far. And the countries that have ratified the treaty that participate in it are known as parties or states parties to the treaty. So that's a little international law vocabulary we can add to our conversation. Cdaw signifies a commitment to condemn discrimination against women in all its forms and to ensure that a country's legal system embodies the principle of equality and protects against gender discrimination. So here I want to highlight a few of the important substantive areas that Cdaw covers. The first is political. It provides for women's equality as citizens, for women's equality before the law, equality of nationality, equal rights to vote and to hold public office. Economic. It provides for equal educational opportunities for girls and boys, women and men, equal employment opportunities, equal pay, equal rights to enter into contracts, to own property, to secure mortgages or bank loans. It provides for equality of rights in the area of family, equality in marriage and family relations, equal rights to freely choose marriage. And in the area of health, Cdaw provides for equal access to healthcare services. Cdaw covers the social and cultural sphere, calling on states parties to strive to eliminate prejudice, to eliminate notions of superiority or inferiority of either of the sexes, as well as stereotyped gender roles. To talk a little bit about how Cdaw works, well, it requires countries to take all appropriate means, to use all appropriate means without delay to end discrimination and to ensure the full development and advancement of women. So states parties commit to address discrimination and to promote equality in areas such as national constitutions, so changing national constitutions to embody the principle of gender equality, reforming laws and regulations to eliminate gender discriminatory provisions, adopting policies and plans to promote equality, eliminating customs and practices that constitute discrimination. And another important part of the way Cdaw works in practice is that there is a committee, as there is with other similar international human rights treaties, that oversees the implementation of the treaty. The committee is made up of independent experts, and it engages in a type of dialogue, it's called consultative dialogue, with the countries that are parties to the treaty. So the committee can make suggestions and recommendations. There is also what's called a periodic review process, which simply means that every 4 years, the countries that are parties to the treaty conduct a self-assessment of their own progress in achieving the goals of the treaty, and they submit reports to the committee. Again, this is similar to the process used to oversee the implementation of other human rights treaties. And that periodic review process is the primary mechanism for the dialogue between the Cdaw Committee and the countries that are part of the treaty. So those are some of the basics about the treaty and how it works. I'm going quickly through a lot of information due to our time limitations today, but obviously there's a lot here and there's a lot that you can explore on each of these issues that we're discussing. Now I'd like to turn to how this particular treaty engages the issue of domestic violence and what implications the treaty has for your work, our work, on the issue of domestic violence. So I just explained to you the Cdaw Committee, which makes recommendations. It makes general recommendations in which it interprets and explains the implications of the treaty. And it is made such a recommendation with regard to violence against women, which basically clarifies how the treaty applies to this issue. This is General Recommendation 19, and that's what I'm quoting from here as I talk specifically about violence against women. So this recommendation clarifies that discrimination, that is discrimination under Cdaw, as that term is used in the treaty, includes gender-based violence. That is violence that is directed against a woman because she is a woman or that affects women disproportionately. The committee has recognized that violence against women impairs or nullifies the enjoyment by women of human rights and fundamental freedoms. It is noted that family violence is one of the most insidious forms of violence against women. It is prevalent in all societies. So notice here, as the committee explains, not only does gender-based violence itself amount to a human rights violation, it also prevents and inhibits women from realizing and exercising their human rights in general in other areas. Looking further at General Recommendation 19 on violence against women, the full implementation of the convention, that's of Cdaw, requires states to take positive measures to eliminate all forms of violence against women. So it spells it out, and it makes specific suggestions of some measures that may be necessary in order to overcome family violence specifically, and that's the second part of this quote with the numbered list here. And some of those measures could include criminal penalties, civil remedies, services to ensure the safety and security of victims, rehabilitation for perpetrators, and support services for families. So these are some specific ways that the treaty has been interpreted and applied to address violence against women, and ways in which the committee has communicated to parties to the treaty what their specific obligations are, what the obligations of governments are under the treaty. So we've been looking specifically at Cdaw, at this one treaty on women's international human rights. I'd like to pull back now and take a slightly broader perspective. This statement is based on an interpretation of Cdaw as well as other international human rights treaties. So this is a statement about human rights law generally. It says, states have clear obligations under international human rights law to address violence against women. States are required to exercise due diligence to prevent violence against women, to investigate such acts and prosecute and punish perpetrators, and to provide redress and relief to victims. This quote comes from a report by UN Women. That's the United Nations entity for gender equality and the empowerment of women. It's an administrative body within the United Nations. And so this statement kind of summarizes government's obligations with regard to violence against women specifically. And recall what we talked about earlier, the three main categories of government obligation: respect, protect, and fulfill. And this statement here is focusing on the protect and fulfill aspects of these obligations. So this makes it even more clear, even more specific. Under international human rights law, governments have a responsibility to do something about violence against women. Now that we've gone through Cdaw, we've talked about international law as it applies to the issue of violence against women, I want to turn to the history of Cdaw in the United States. And I'd like to pose a question. I hope you can see this question on your screens. If not, listen closely. The question is, what year did the United States ratify or join the Convention on the Elimination of All Forms of Discrimination against Women? What year did the U.S. join Cdaw? Remember, this treaty was adopted by the UN in '79, entered into force in '81. The answer is that the U.S. has not joined Cdaw. The U.S. is one of only 6 nations that are not part of the treaty. The U.S. played an active role in the treaty negotiation and drafting process. The Carter administration signed Cdaw in July 1980, which signifies an intent to ratify the treaty, and it submitted Cdaw to the U.S. Senate in November 1980, and the treaty has remained there ever since. The 2/3 approval of the Senate is required for ratification. So who are the other countries that have not ratified Cdaw? The others include Iran, Somalia, Sudan, Palau, and Tonga. The U.S. is the only Western democracy that has not joined. All of our allies have joined. And the U.S. is in yellow to illustrate that it has signed the treaty, but that it has not ratified. The countries that are in red have not signed the treaty, have not taken that step. And just so it's not a distraction, the different shades of green simply signify different ways in which the other countries have become parties to the treaty. There is broad-based support for U.S. ratification of Cdaw, including a coalition of up to 190 religious, civic, and community organizations at the national, state, and local levels. A large number of Cdaw's supporters are faith organizations, and I've listed a few here to illustrate, and this is drawn from several sources to give you a sense of the variety of support for the treaty. So I imagine the question that's bubbling up right now is why? Why hasn't the U.S. joined Cdaw? Here I've been talking about the values behind international human rights law, the ways that it can be utilized to address concerns about violence and other human rights abuses. Cdaw is one of the main international human rights treaties. It has a parallel, for instance, there's a Convention on Elimination of Racial Discrimination that the U.S. has ratified, thankfully. And so there are other of these types of treaties, some of which the U.S. participates in. But the U.S. hasn't joined Cdaw. We want to know why. Well, this, as you can imagine, it's a complex question that continues to be debated and explored by scholars as well as activists. So it's not like there's one kind of approved answer. But let me offer for your consideration my theory based on my research and analysis and reflection. And I think the reasons fall into two main categories. One, general objections and challenges that frequently arise when the U.S. is considering joining an international treaty, especially an international human rights treaty. And I'm just going to name these and go through them pretty quickly due to time constraints. We could definitely have conversations about each of these points. They're all worthy of exploration. But just to kind of get the main arguments out on the table. Okay, first, state sovereignty. Here, again, I mean nation state or country. I don't mean states within our United States. So just to clarify that. So sovereignty of nation states is a foundational principle of international law which has evolved to some extent with the advent of international human rights law since the post-war period. So to the extent that this is an issue or a concern, it's kind of a general issue or concern that applies to international human rights broadly. Second, national interest. This has come up in the congressional debate. Is it in our national interest? How does it benefit us? Well, I would certainly argue, I will argue later in the presentation, that ratifying the treaty is in our national interest, even narrowly defined. And I hope that we can affirm that the other international human rights treaties we ratified, like the Convention on Ending Racial Discrimination, is in our national interest as well. But this is an issue that continues to be raised. Third is a question of what I'll call political will, just generating the urgency, the momentum to prioritize a certain issue and a certain treaty. And so that's part of what's at play in getting a treaty ratified. Then there is the United States' preference for full compliance with an international treaty before ratifying it. So by that I mean the U.S. would like to know that it is meeting every single provision of the treaty before it ratifies it. However, especially with regard to Cdaw, this is not what the treaty requires or asks. Rather, it asks for commitment to a principle and a promise to make progress, to take reasonable measures in reasonable amounts of time to move forward toward achieving the goal of eliminating discrimination. It doesn't expect a country to do this instantaneously. So the treaty was designed for what we call progressive implementation or compliance, meaning it can happen over time. That there's just resistance in our U.S. context to ratifying a treaty in that situation. And then last, just procedures and timing of the ratification process, getting on the Senate calendar. So twice, Cdaw has received favorable reports from the Senate Foreign Relations Committee with bipartisan support, but it has never made it to the Senate floor for a vote on ratification. So something as simple as that is also an issue. Not simple, but I mean identifiable. So all of those general objections, again, they would be issues for any type of international human rights treaty. There are also objections, however, raised to U.S. participation in Cdaw that are more specific to this actual treaty. And I also want to make you aware of these so that you can have a sense of kind of what the issues are and what the discussion is about. I believe that there are objections to the scope and the breadth of the treaty. The treaty addresses economic, social, and cultural issues in its effort to address, as the title tells us, all forms of discrimination and to promote substantive equality and not just formal equality. So it addresses equality in issues like healthcare and housing, and the U.S. is traditionally resistant to recognizing these as human rights issues. But I think the heart of the specific objections, and I think really the heart of the debate over ratification, in my view, is the question of gender equality, the question of the principle that the treaty stands for. So there's objection and opposition to this principle, which underlies many of the the statements by opponents or detractors from the treaty. And I think it's also fair to say that many of the objections that are raised in this general category are motivated by this specific concern or interest. So for those of you who are familiar with the debate over the Equal Rights Amendment in the United States, you could draw something of a parallel in terms of the principle at stake. And as with the ERA, there is a vocal and highly mobilized opposition to the treaty. I think of it as discrete because it's represented by a relatively small number of groups in comparison to the 190 civil society organizations that support Cdaw. And because of our context, I also want to make you aware that I think some of the most effective detractors from the treaty would cite to, quote, biblical values as they understand and interpret them as underlying their commitments and their policy positions. So there's kind of a fervent, committed opposition that lays claim to biblical values in opposing ratification of Cdaw. So that's part of what's going on. And with that in mind, I'd like to outline an alternative position based on my own Christian ethical analysis, which arrives at a different conclusion, in fact, the opposite conclusion, regarding what we should do about this treaty. So I call this an outline. Again, we could talk at length about each of these points, but first I'll just lay them out for you. I begin with some core religious values. Human dignity, our starting point. The dignity of all human beings, all made in the image, I believe, of God the Creator. Then I go to justice, a central value in so many religious traditions. We can speak of the centrality of justice in the prophetic tradition of the Hebrew Bible. We can think of Jesus' own self-understanding as proclaiming the kingdom of God, a kingdom marked by love and justice, of Jesus' teaching of love for neighbor as primary, and the just treatment of others as being the perfection of our love. And then the third main value or theme that I draw from the Hebrew and Christian scripture is compassion for the widow and orphan. The widow and orphan, which is used in the Bible, we know, to represent the marginalized and the vulnerable, whom today, as in biblical times, are very often women and girls. So recall the figure of 1 in 3 women in the world today suffering violence at the hands of a family member. The widow and orphan. So we have these values, and then we have the reality of 1/2 of humanity being at risk of violent abuse. And then I think of our duty, those of us who are faith leaders, even people of faith, our duty to proclaim that the current reality, that this tremendous risk of violence for women simply because they are women, is not God's desire or will for the world. I think we have a duty to proclaim God's desire for love, peace, and justice, and a duty to envision a better world and to endeavor, with God's help, to bring this world about. So I trust that we can agree on the value of justice, the value of overcoming violence. And what I'd offer to you today is that international human rights law is one tool, though quite a powerful tool in its way, for redressing and preventing injustice. It's a tool with tremendous potential. In the case of Cdaw, largely untapped potential for addressing problems as widespread and seemingly overwhelming as violence against women. And then the last point I end with is women being equal before God. And I just speak out of my own tradition, which is a Protestant Christian tradition, that even among the breadth of different religious views that I know exist about the nature of men and women, we do affirm women's equal dignity before God as creatures made in God's image. And thus, women should receive equal regard from the state, from the government, in this case in the form of protection against violent abuse. So just to summarize the ethical argument I've sketched out so briefly here, if our desire is to respect human dignity, if we're concerned about justice, if we want to do justice, if we have compassion and concern for the most vulnerable, the 1 in 3 women who is victimized, there is a powerful tool that our country could utilize as both a demonstration of commitment and as a method of engaging to reduce the risk of violent abuse to women and girls. Now, pulling back from my Christian ethical argument and kind of stepping into a broader, more secular frame once again, I think there are a variety of benefits to U.S. ratification. Some of the benefits that scholars have cited are that ratification would renew and proclaim the United States' commitment to full and equal citizenship of American women. This would enable the U.S. to participate in one of the most relevant global conversations about effective strategies for overcoming violence against women. It would mean a commitment by our government to examining why U.S. laws, policies, and practices have not yet stemmed the problem of violence against women. Notice that the prevalence of this problem in the United States is very similar to the global prevalence. And this would also be a way for the U.S. to fulfill its leadership potential in promoting women's human rights both at home and abroad. So I mentioned tremendous untapped potential, and I think joining Cdaw is an important way to take hold of that potential. Now, let me be clear, I'm not saying that treaty ratification is somehow an ultimate solution. That's not the claim I'm making. But it is an important and necessary step forward. I also don't exactly think of treaty ratification as an end in itself. It's a goal, but not an end. It would be a meaningful statement an affirmation of the United States values as a leading democracy, and it would open up the possibility of progress toward the worthy goals of justice and equality for all. On the flip side, there are consequences to the failure of the U.S. to ratify. So by choosing not to ratify, these are some of the barriers the U.S. faces. And here I'm quoting someone I respect greatly. This is Harold Koh, who is currently the Sterling Professor of International Law at Yale Law School. Professor Koh, or Dean Koh, is formerly a dean of the Yale Law School, formerly legal advisor to the U.S. Department of State, and one of the country's leading experts in human rights. And he said, "America simply cannot be a world leader in guaranteeing progress for women's human rights, whether in Afghanistan, in the United States, or around the world, unless it is also a party to the Global Women's Treaty. Our continuing failure to ratify Cdaw has reduced our global standing, damaged our diplomatic relations, and hindered our ability to lead in the international human rights community." So to end on a hopeful note, let me offer a few ways you can be active with regard to this issue. First, you can start by learning more. So I hope that I've generated some thoughts and given you some points to reflect on with regard to these issues, but I really invite you and encourage you to not just take my word for it, but continue reading about these issues. And I provide a list of resources at the end to help you do that. And if you do want to see the United States ratify Cdaw and participate in this treaty as a method of addressing injustice based on gender, then the steps you could take would be to urge the presidential administration to prioritize ratification, to urge your senators to support ratification. You could also find out if your state, county, or city is one that has passed a resolution implementing Cdaw at a local level. So many have done so in the absence of national action, are making their own efforts to implement the principle of equality at a local level, which is really exciting. And then lastly, I invite you to share what you've learned with friends, coworkers, neighbors, and policymakers. I also invite you to continue the conversation. I would welcome your comments, your reflections, your questions. Thanks for your time. This has been a pleasure, and I'm glad that you could join me today. Here we have our list of resources. Thanks again.